Thank you, everyone, for joining. I have some breaking news that we'll talk about briefly, but I'm here with Cecilia Wong, the National Legal Director of the ACLU. Very lucky and very happy that she is able to attend right now. And the breaking news, of course, the Supreme Court has just decided to issue a stay of a lower court ruling that had paused the Trump administration's attempt to effectively dismantle the Department of Education. And the reason I'm mentioning it now, Cecilia, is that it seems analogous to some shadow docket rulings in ACLU cases, but just for folks who are signing in right now and haven't heard of the ruling, I just want to read a little bit from Justice Sotomayor's dissent. It was a 6-3 ruling, very similar to a lot of the 6-3 rulings allowing the Trump administration to do certain things on a temporary basis, where that temporary can be a long period of time and very destructive. But Justice Sotomayor says early in the ruling, when the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. She says at the end of the ruling again, this is the Supreme Court majorities allowing the Department of Education and Linda McMahon to go ahead with mass layoffs of a large number of staff. Says Justice Sotomayor wrote, the president must take care that the laws are faithfully executed, not to dismantle them. That basic rule undergirds our Constitution's separation of powers, yet today the majority rewards clear defiance of that core principle with emergency relief. And with that introduction to pivot to the kind of more hopeful topic of today's conversation, Cecilia, which is your and my shared belief that the legal counteroffensive is in many ways working. So how do we reconcile these two beliefs? That right now we've had a number of Supreme Court rulings on the emergency docket. This is one of a number, and one is an ACLU case that I want to ask you about very soon, where the court, without a word of explanation, is letting the Trump administration move ahead with a very sweeping change in the way our government is ordered. And here, seemingly moving forward with the dismantling of a government agency, which is Congress's power. So with that broad question, where is the, even with repeated rulings and headlines of the Supreme Court giving the Trump administration this authority, where does the legal counteroffensive head from here?
So I think the way we reconcile news like the news you just broke, to me at least, I was sitting here and hadn't seen that headline yet. I think the way we reconcile headlines like that with the continued righteous efforts of the legal defense against the Trump administration's offensive on the rule of law and the rights of minority communities, marginalized communities, the First Amendment, everyone's civil rights and civil liberties, is that genuinely, I think you see a mixed bag. Even if you only look at the decisions of the Supreme Court over the course of the term that just wrapped up, on the emergency docket, the ACLU had 5 cases up at the court. And in 2 major cases where we've challenged the Trump administration's lawless behavior, we basically took a win. And so I think what you saw over the course of the term was first the Supreme Court in 2 of our cases where we're challenging Trump's invocation of the Alien Enemies Act, this, 18th century wartime authorization for presidents to detain and deport people who are nationals of a country the U.S. is in a declared war with. You saw the court really standing up for the rule of law and for the idea of due process. first in a case called JGG, which was our initial case brought in the U.S. District Court in Washington, D.C., and then in a second case that we brought in Texas. In both of those cases, the Supreme Court said the government can't bypass, due process altogether and deport Venezuelan nationals to this gulag in El Salvador, the CCOT prison. They have to at least give advance notice that they intend to deport someone under the Alien Enemies Act, and they have to give people an opportunity to go into federal court and file a habeas corpus petition asking courts to review what the executive is trying to do. So you see the court in these key moments over the course of the last term really holding the executive branch to account, inserting critical due process protections. And even most recently, last week, we had the Supreme Court deny a stay application by the state of Florida, which was asking the Supreme Court to put on hold a lower court decision that we had won that basically blocks a new anti-immigrant Florida state law from going into effect, right? So not a Trump case, but certainly about one of Trump's key issues in the administration. So it's been a real mixed bag. You see over the course of the term, sometimes the court really standing up to the Trump administration, and other times, in some cases, really bending over backwards to give the Trump administration a go ahead to go forward with his policies that lower courts had held to be unlawful, at least on a preliminary basis.
Right. And for the latter category, kind of pivoting to the DVD case, you were talking about due process. I think what was so puzzling about that case in particular, these are 8 men being sent to South Sudan. They are now in South Sudan because of a pair of Supreme Court orders. And there's not a word of explanation that comes in it. So, from someone inside that litigation, the rest of us are here to try to divine something from the Supreme Court's silence, because, as you said, in other cases, they are upholding the principle that some notice and hearing and due process is due. Where do you think the Supreme Court is drawing the line?
So it's really hard to discern the line. I should say first that the DVD case is not an ACLU case. I don't want to take credit for that righteous and amazing work that the National Immigration Law Alliance and the Northwest Immigrants' Rights Project are doing with others. But DVD is really a travesty of a case. I don't think it's a problem in itself that the court reaches these really consequential decisions on its emergency docket without having to provide reasons. Typically those cases get to the court on very abbreviated briefing. In the genuine emergency situation, the court is taking kind of a preliminary cut based on very limited information to try to freeze the status quo traditionally in these cases. So I don't blame them for not writing a fully elaborated opinion. I think what's troubling is what Justice Sotomayor has pointed out, which is the court, or a majority of the court, seems to be throwing out the normal rule that if you're asking for a lower court's order to be blocked or frozen while the case is ongoing, usually you have to show a few things. The first is that you're likely to win on the ultimate issue in the case. The second is that you're harmed. The party that's trying to get the court to issue this stay has to show that they're harmed. And in DVD and numerous other cases where the court has issued these orders, for example, the Humphreys Executor case with Gwen Wilcox and other federal officials who've been removed by the Trump administration, the government came in and said to the court, we want you to pause the lower court's decision, but they don't show any harm from that lower court decision, right? In the DVD case, you had these men who were not nationals, except in one case, not nationals of South Sudan, who had no ties to South Sudan. And the government wanted to deport them bypassing ordinary immigration court procedures. They wanted to bypass the immigration courts and send them to a country, apparently for the cruelty of it, to this country that's on the verge of civil war, and to terrorize people and to make an example. And as Justice Sotomayor pointed out in dissent, the government didn't show any harm that would be caused by letting the lower court preliminary injunction stay in place so that people aren't deported to be in danger, while the courts are considering their claims, in the normal course of litigation. And so, I think you see the court reaching inconsistent results, as you pointed out. It's just a bit of mixed bag. Steve Laddick, a legal commentator, and others have, kind of thrown out the possibility that the Supreme Court or a majority of the court is worried about having a limited amount of capital to spend in opposing the Trump administration. And given that they gave the rule of law and plaintiffs, big wins on Alien Enemies Act and a few others, they've now scaled back. So I think it remains to be seen. I think that next term, and as the summer goes on, if we see more emergency applications where the court sides with the Trump administration, I do think you're going to see the Chief Justice of the Supreme Court starting to worry about the legitimacy of the court when it's issuing these rulings that really set aside, as Justice Sotomayor says, and as Justice Jackson has said, the ordinary rules that apply to these emergency applications.
I want to return to the third country deportation topic a little bit later because there was big news that broke on that particular topic today in the Washington Post. But I want to turn to a victory that the ACLU recently had in New Hampshire. I was there to see it. It was a class action victory on birthright citizenship out of the District of New Hampshire. And I wanted to highlight that because a lot of people were concerned uh, in the wake of the CASA decision that the federal judiciary had been weakened, it had been gutted. And very, very quickly, a federal judge has now blocked the birthright citizenship ban nationwide. What did the ACLU show in getting such quick relief in the wake of that Supreme Court decision?
So, within 2 hours of the Supreme Court's decision on that emergency application on birthright citizenship, the Trump versus Casa case, we filed a new proposed nationwide class action lawsuit on behalf of expecting parents whose babies would be subjected to Trump's ban on birthright citizenship. And as you have said, we were fortunate in having our class certification motion granted very quickly and getting a preliminary injunction really quickly. I frankly was not surprised by that result, Adam, because every lower court in the many cases that have been brought challenging the birthright citizenship ban around the country has held that Trump's order is unconstitutional. He's going up against the Reconstruction Constitution, the 14th Amendment, as it was ratified after the Civil War. He's going against a Supreme Court decision that underscored the right to birthright citizenship under the 14th Amendment. And he's going against a statute enacted by Congress that codified birthright citizenship in the U.S. Code. And so it's no surprise that, I said from the beginning of the Trump administration, the second term, that I don't usually predict how our litigation is going to turn out. But I did predict that we will ultimately prevail on birthright citizenship because it is probably the most unlawful and blatant example of lawlessness by this administration that we've seen. And that's saying a lot, given what his record has been.
Mm. Well, what is that ruling in terms of proof of concept about the ability of class action litigation in particular to block illegal or unconstitutional initiatives by Trump?
So, why don't we go back to the Trump versus Casa decision? Because I
Sure,
think it
absolutely.
was really overread, certainly by the Trump administration when he went into the, went and told the media that he had scored this enormous victory on birthright citizenship, when in fact the order doesn't say anything about birthright citizenship itself and says very little about the federal courts, the lower federal courts' ability to grant injunctive relief to block unlawful executive actions from going into effect. So, in the Trump versus Casa case, the lower courts, three federal circuit courts, had all ruled in favor of the plaintiffs. 22 states, several nonprofit organizations, and individual expecting parents saying uh, that they entered basically a nationwide injunction saying this executive order is unconstitutional. The Trump administration then files this emergency application not to challenge those rulings of the lower courts on the merits, but simply to say that the lower courts should not have entered if effective relief nationwide. They wanted the Trump administration, wanted the court to take up this issue that some of the conservatives on the court have been concerned about for some years of whether lower courts can issue so-called universal injunctions, which basically say that in holding that an executive action is unconstitutional or unlawful, they're basically telling the federal government you can't enforce this as to anybody in the country. And so, what the court did in the Trump versus Casa case is to agree with that and to say, um, the lower courts should not have simply said that this executive order is unenforceable. At most, they could only say, as to these plaintiffs, the Trump administration can't enforce the executive order. Now, what can that possibly mean in a case like this, where 22 states are challenging an executive order that says babies born in the United States to parents who are either undocumented or who are here lawfully, but with temporary visas, are not US citizens? If someone's born in one of the other 28 states, but then moves to the 22 states that have this injunction in place, how does that even work? We're going to end up with this unworkable patchwork on birthright citizenship. So, the court basically said we disapprove of universal injunctions. Courts should only grant relief to the plaintiffs who are before them. But the court leaves open the possibility that even these lower courts in the 22 states cases and the other ones that were in front of the court could still enter nationwide injunctive relief. They just have to explain why that's needed to provide full relief for the plaintiffs that were in front of them. The other thing that the court left open, of course, was the possibility that there are other avenues to getting nationwide relief on birthright citizenship and other issues. And that's one of them is that you file a nationwide class action. And that's exactly what we did. The court's ruling in Trump versus Casa doesn't touch the possibility of class actions or another mechanism, which is to go into court and say that an executive action that was implemented through the Administrative Procedure Act should just be set aside because it was unlawful. So there are a few different avenues besides asking for a so-called universal injunction, that are still open to civil rights plaintiffs and other plaintiffs who are challenging unlawful government action.
And this particular class action was led by a woman who, under the pseudonym Barbara, who is due in October. It must be a huge relief for her over in New Hampshire. So that report that I wanted to ask you about a little earlier, it's breaking this morning out of the Washington Post, and it's about how broadly the Trump administration interprets its ability to whisk people out of the country to a country that they have never been to, the third party deportations. And according to the Washington Post, that they believe, even if they don't have a country's assurance that an immigrant won't be tortured, say in El Salvador or South Sudan, they can give 6 hours notice. That's sufficient. And they don't need to go through any of the fuss if they have assurance by someone at the other end. That's how they interpret it. Is this likely to be litigated? And how do you think that the revelation of this memo will be responded to? What's the viability of this MO from the Trump administration to actually be going forward?
So, I'm not one of the lawyers on the DVD case, so I don't
Right.
want to speak to, how they're going to litigate it. They're extremely good lawyers, and I have every confidence in them. So maybe the way to answer that is to say the Supreme Court in our Alien Enemies Act case, also about deporting people without due process, was went to the Supreme Court on the second emergency docket application with our application for relief. When we heard from our clients who were detained at this ICE facility near Abilene, Texas, that they had gotten this piece of paper from ICE agents in the ICE detention center. And they, were able to glean from this that the government was saying, we're going to deport you to this torture prison in El Salvador sometime today. They got this notice sometime after midnight. It was just a few hours after the federal district court had denied our application for emergency relief, saying that there was no indication that our clients were in any immediate danger. And the Trump administration went right in after the lower court denied that application for temporary restraining order by giving people a piece of paper saying, by the end of the day today, we are going to deport you to El Salvador, to this prison. And we went to the Supreme Court and said, this bypasses due process. 24 hours is not long enough. And the Supreme Court agreed with that. And a majority of the Supreme Court said, in telling the Trump administration they cannot deport any of our clients, they said, look, 24 hours is not enough for someone to go into court and ask for due process, to ask for a hearing before they're deported, potentially to their deaths, in El Salvador. I think the same reasoning applies in DVD, notwithstanding the court's previous responses to the stay applications. You can't expect someone to ask for due process by going to a federal court within a matter of 4 hours or 6 hours. The court has already said 24 hours is not enough in an equivalent situation, and it certainly isn't enough when the government is trying to bypass ordinary immigration court procedures for designating what country you're going to be deported to.
Mm. And another breaking report that might be relevant to our broader discussion on the viability of the legal resistance to the Trump administration's agenda. The breathtaking statistic from Reuters, they looked into the attorneys from the DOJ who quit rather than defend the Trump administration's policies. 2/3 of that office has quit. And I can say anecdotally, in covering a lot of these high profile cases, what I've noticed is very senior officials from Main Justice are arguing before the court in these cases. It's not people at the U.S. attorney's offices. How does that brain drain affect everything? How can set aside the viability of these policies to begin with? Um, does that augur some hope from folks like the ACLU in opposing this, that the DOJ just lost a good number of the people who are being called upon to defend these illegal or unconstitutional policies?
So I think, again, this is another situation where, um, it's a mixed bag. The fact that 2/3 of Justice Department lawyers who are have declined to stay there
I'm sorry, Cecilia, I lost you. Are you still there? I don't know if that's your connection or mine. I don't know if you can hear me, but I lost. Sorry, everyone. I think I'm going to try to have her join the feed one more time. I think we had a connection issue, but so you guys can still hear me. I'll add some of eventually when this is, when the interview is over, and if we hopefully can connect to her again. But I'll send you in the everyone who's a subscriber will get the newsletter of today's conversation. In the show notes, I'll have all of the breaking news reports that we spoke about today, the Reuters report, and also the report from the Washington Post about that breathtaking memo about what ICE believes is adequate notice and process before sending someone to a third country. Um, but see that having a little bit of trouble connecting to her. But yeah, no, I just to give my own commentary on that particular Reuters article, I can see why she said it's a mixed bag. It also means that two-thirds of the people from that office are did not want to stay with the administration because of that feeling of interference, as we've seen in other cases in the Eric Adams case or the cases involving the appropriations from the Greenhouse Gas Renewal Fund. It seems that we're having a little bit of trouble reaching her. I'm going to try texting, but that might be the end of the interview if we can't reconnect. So thank you, everyone, for joining. I'm just going to pause for a second to try to text to see if the tech issues can be resolved. So while I'm waiting, and this might actually be a point to end on, I will read a little bit. Some of you were not on the live stream when I mentioned this. This was at the beginning of the interview. But I had mentioned there had been a breaking Supreme Court ruling where, again, we saw a 6-3 breakdown where the court on the emergency docket, without a word of explanation, allowed what has been described as the effective dismantling of the Department of Education. And Justice Sotomayor, along with Justice Kagan and Justice Jackson, dissented. I'm going to read a little passage from the end of the dissent saying, lifting the district court's injunction will unleash untold harm, delaying or denying educational opportunities and leaving students to suffer from discrimination, sexual assault, or other civil rights violations without the federal resources Congress intended. The majority apparently deems it more important to free the government from paying employees it had no right to fire than to avert these very real harms while litigation continues. Equity does not support such an inequitable result. I'll be writing about this breaking ruling tonight. If you subscribe to All Rise News, that will be part of when I send out the interview, along with that's from Justice Sotomayor's dissent, and along with all of the other parts from today's show notes. It doesn't seem like we're able to reach her again, so I'll just end it there because of the connection issues. Thank you, everyone who joined, and remember to subscribe for All Rise News if you missed any part of the interview and you want to just catch any part of it that you missed and read the article accompanying it with the show notes. A lot more to come. Thank you for joining.